Defendants charged with participating in the same conspiracy are often prosecuted in a single trial. But if the conspiracy charges are dismissed, can the defendants still be tried together for their remaining separate crimes? The Supreme Court considered this question in Schaffer v. United States. 3 members of the Stracuzza family were indicted for conspiring to transport stolen goods in interstate commerce from New York into multiple states. Max and Norman Schaffer worked with the Stracuzzas to ship children's and women's clothing from New York to Pennsylvania. Hyman Karp and Benjamin Marco assisted with shipments to Massachusetts and West Virginia, respectively. The Schaffers, Karp, and Marco were subsequently charged with knowingly transporting stolen goods across state lines and with conspiracy. All 7 defendants were prosecuted in a joint trial. Each of the Stracuzzas either pleaded guilty or had charges dismissed at trial. At the close of the prosecution's case, the remaining 4 defendants, the Schaffers, Karp, and Marco, moved for an acquittal. The district court granted the motion on the conspiracy charges, finding that the defendants had no connection to each other beyond their individual shipments with the Stracuzzas. However, the motion was denied on the substantive charges, and the court ruled that the defendants wouldn't be prejudiced by their joint trial. The judge instructed the jury not to consider evidence against one defendant as evidence against the others. All 4 defendants were convicted and sentenced to prison. They appealed, arguing that they shouldn't have been tried together after the district court acquitted them on the conspiracy charges. The Second Circuit affirmed the convictions, holding that trying the defendants jointly didn't result in prejudice. The Supreme Court granted cert.